And I find that President Barack Obama just signed same-sex marriage into law. And I respond, yes, now I can marry my sister. So you can see there's something wrong with that conclusion. And the reason why there's something wrong with that conclusion is because it's out of place. That is, a conversation about same-sex marriage or a conversation about marriage equality should be about same-sex marriage or marriage equality. Conversations about polygamy or bestiality or incest or those things, those are other conversations that we might or might not need to have. So I'll stick to what the conversation is supposed to be about, and that is same-sex marriage. The other thing that Dr. Brown omitted to tell you is that this ought to be a legal conversation. It ought to be a legal conversation. He talked about redefining the institution of marriage, but he didn't tell you anything about law. So let me tell you some things about law. At the beginning of the country, or the founding of the country, one of the things, or probably what was the most contentious issue, was that of slavery. Now, I won't go into the analogy that he talked about, but I will tell you this. As a way of continuing that conversation, what the founders did was they took what we established as the U.S. Constitution and put provisions for slavery in it. In fact, I was just talking to the debate team last night, and I showed them the places in the U.S. Constitution where there are provisions for slavery. And I won't go through those now because I'm sure you all know this. But what they also did, and this was the genius of America, what they also did is infused into the American creed principles, Enlightenment principles of justice. Those principles include things that you don't see in black letter law, but you often hear courts talking about, like privacy, or equality, or freedom, or liberty, or choice. So what that means is America was caught in the position of struggling between its practices of things like slavery and its Enlightenment principles of things like freedom, equality, choice, privacy, and so on. And that forced the conversation about slavery to continuously come up. Eventually, you know the story, so I don't have to go into what happened in the story. But I'll point out that this is a representation of the fact that we've been struggling over time. You've seen this conversation come up many other times. So, for example, when it comes to the liberation of women, America was caught in the same struggle between its practices and its principles. And with civil rights, America was stuck in the same struggle between its practices and its principles. And of course, here, we're again in the same struggle. So the question of what have you been watching over the last 30 years is simply that struggle. We're trying to figure out what is the proper organization of the state given the Enlightenment principles that we've accepted. And so when Dr. Brown tells you that this is a question about the redefinition of marriage, well, yeah, that's a secondary issue. More importantly and foundationally, it's about what kind of democracy we'll be. Will we continue to be a liberal representative democracy grounded on Enlightenment principles, or will we be something else? So that's the question that you've been watching, or that's the question that you've been seeing unfold, and that's the question that Dr. Brown and I will be debating today. I also noticed that he mentioned Lawrence v. Texas. Lawrence v. Texas is particularly important here because in Lawrence v. Texas, Sandra Day O'Connor tells us that Bowers v. Hardwick, which was the rule, the prohibition against same-sex engagements, or the prohibition against homosexuality, generally speaking, is undermined by the principle of privacy. And in doing that, she answered the question that we've been struggling with, at least with respect to homosexuality. So throughout the South and in many states in the Union, homosexuality was straightforwardly outlawed. And certainly engaging in homosexual relationships was straightforwardly outlawed. And the Supreme Court decided this question for us, legally speaking. And they answered in terms of our principles, namely, in this particular case, the principle of privacy. And I want to point out something else to you with respect to redefinitions. Think about what happened with Roe v. Wade. We had two principles in conflict with one another. One, life, the second one, choice. We ultimately decided that question in favor of one principle, namely choice. And the reason why I'm pointing this out again is because I'm highlighting what this struggle is really about in America. Okay, so that's what it's about. Now the question that I am tasked with answering is, why should same-sex couples be allowed to marry? That's my question. I want to point out to you, though, that Dr. Brown simply gave you a history lesson. He didn't tell you specifically about why same-sex couples should not be allowed to marry. He gave you a history lesson, and I'll talk about that history lesson in my response. But before then, I want to tell you why same-sex couples should be allowed to marry, and this won't take that long. One thing that institutions do, political institutions or legal institutions or social institutions do, is distribute the benefits and burdens of society among the citizens in a society. So, same-sex couples, for example, carry the benefits of the burdens of society in the same way that straight people carry the burdens of society. So let me give you an example of some of the burdens of society. They participate in the military. They pay their taxes. They are members of public service institutions. So for example, they might be in healthcare, they might be in education, they might be in transportation or sanitation, and of course they give to charity. So in these regards, they carry the benefits of society just like the rest of us carry the benefits of society. If you're wondering why, then they should be able to participate in the institutions of society that give benefits. Well, the answer to that is because they carry the burdens like the rest of us. So they should be able to participate in those institutions that bestow benefits on us, just like the rest of us. And marriage, of course, is a benefit in American society. There are other benefits in American society, and of course you know these, so I need not tell you about them. Certainly those of you who are married know many of them. That once you become married, then you enjoy the benefits of being married. Some of those benefits are tax breaks and those sorts of things. And the answer to his question then is, because they carry an equal measure of the burdens, then they should participate in an equal measure of the benefits. And of course here I mean equal regarding their numbers to straight people. So that's my answer to your question, Dr. Brown, at least straightforwardly. In order to answer this question, I need not get into a conversation about homosexuality is the new black or any of that sort of stuff, or I need not talk about religion. That's simply one answer to the question. There are many ways to answer the question. I've just given you a benefits burden analysis. And of course, people who've been in law school, you've heard that story before about benefits and burdens and distributing the benefits and burdens. Sometimes we call them the bundle of rights in society. And I notice the lawyer here, John Stenberger, is here. I'll say hi to him now. But that's why, or that's my answer why, and it's at least one answer to why. So I'll stop here and let the conversation between myself and Dr. Brown move on. Thank you.
I'd like to thank Dr. Smaw for his opening remarks and now reintroduce Mr. Brown for his response.
Okay, I do very much appreciate the demeanor and spirit of Dr. Smaw and what he brings in terms of logic and philosophy and law. I was a bit surprised that the opening comments became somewhat of a rebuttal. I thought this was totally contrary to debating procedure, but in any event, what it meant was that we never really got to hear why same-sex marriage should be legal, because I didn't give a history lesson. I talked about what marriage is. I didn't go through, if I gave a history lesson, I'd still be giving it for about another 1,000 years, because this is the only history I've ever had, is that marriage is the union of a man and a woman together for the purpose of responsible procreation. So check this out. ABC is not math. 2 plus 2 is not spelling. Male plus male, female plus female is not marriage. So we haven't had that addressed at all. So everything that I said about that remains 100% intact, untouched. The fact that gays participate in society, of course. The fact that marriage of 2 men or 2 women is not marriage doesn't change that fact. And let me just say one other thing. As a heterosexual married for 35 years, I didn't get married for tax benefits, and I could care less if I have to pay triple to be married. And I could care less if I get inheritance rights. I'm married out of a lifelong commitment to my wife. And if the government recognizes it, that's their benefit. And if they don't, that's their loss. Just to say that. Okay. To say this is not about civil rights, it has nothing to do with civil rights. For example, if I want to do something that only a woman can do, it's not a civil rights issue. If I want to have a baby, notwithstanding the so-called pregnant man nonsense, but if I want to have a baby, I can't do that because I am a male. So 2 men cannot marry because